Okay, now please all rise for the arrival of the School of Law Dean and faculty. Please remain standing for the entrance of our guests. Guests of honor, Attorney Christopher John P. Lau, Attorney Joseph Peter Calleja, Professor Dante Gatmaitan, Honorable Justice Conchita Carpio Morales, and Honorable Justice Antonio Carpio. Thank you so much for being here today for the lecture of Justice Antonio T. Carpio. To formally start this momentous event, I would like to call on stage Ms. Angela Consignado, President of the School of Law Ministry, for the opening prayer.
Let us pray in the name of the Father, the Son, the Holy Spirit. Amen. Dear God, we come before you today with grateful hearts as we ask for your blessings and protection. We ask for your blessings upon this event and upon each and every person present here today. As we begin this special event, we pray that you will guide our thoughts, words, and actions. May everything we do done with love, kindness, and respect for one another. We thank you for bringing us together and giving us the opportunity to learn, grow, and connect with one another. We ask that you guide us during this program, help us to be open to new experiences and ideas. We pray for our professors, students, and staff who have worked hard to prepare this program. We ask that you bless them and their efforts, and may they feel appreciated for their hard work and education. Bless the participants that they may present their arguments with confidence and humility. And bless the audience that may we listen with open hearts and minds, and may this activity not only sharpen our reasoning, but also strengthen our values of respect, camaraderie, and the pursuit of truth. We also pray for those who are unable to be with us today, and may they feel your presence and love wherever they are. We offer this prayer in your holy name. Amen. That in all things, God may be glorified.
Now please remain standing for our national anthem.
Mga kababayan, ang pambansang awit ng Pilipinas.
Good afternoon, everyone. Kindly take your seats and settle down as we prepare to begin our program in a few minutes. Now, we would also like to remind everyone to observe proper decorum throughout this event. Let us maintain a respectful and solemn atmosphere. We would like to take this moment to express our heartfelt gratitude to the generous partners who helped us make this event possible. School of Law Government, Volunteer Corps, Centralized Bar Operations, and Rappler for streaming live our event this afternoon. Now, okay. Good afternoon, ladies and gentlemen and guests. To those who are watching live on Facebook and in other social media platforms, we are thankful that you have tuned in with us and you are here with us in this moment. I am Iman Torres from San Beda College, Alabang, a first-year student, and I am honored to be your host for this event. Now, it is my distinct honor to introduce our Dean, Attorney Ulpiano Sarmiento III. Dean Sarmiento is a respected legal scholar, practitioner, and educator whose leadership has continuously guided the San Beda College Alabang School of Law towards excellence and relevance in the ever-evolving legal landscape. With this steadfast commitment to legal education and his passion for molding future Bedan lawyers, Dean Sarmiento has been instrumental in strengthening our institution's role as a beacon of justice and service. Again, join me in welcoming our Dean, Attorney Ulpiano Sarmiento III.
The way you introduce as though I am the principal speaker na. So anyway, initially, of course, the very honorable retired Senior Justice Antonio Carpio. Of course, I will look up much to Justice, retired Justice and Ombudsman Conchita Carpio Morales, the faculty of UANP and the other institutions that did come over here far south. Welcome. I hope you get to enjoy the fresh air, free from the pollution that you do have in the north. I do not know if there are students here from San Beda Mindiola, but I was telling Justice Carpio that we are likened to a developed world here because of our compared to that in Mindiola. But anyway, I am supposed to welcome you. Just a short message. It has been noted that, I quote, weak minds compete. Away-away pag mga tanga. Tingnan nyo ngayon, ayoko nang magbanggit. Strong minds collaborate. Today we are deeply honored and privileged to be in the presence of two of the most respected legal minds of our time. Of course, former Senior Associate Justice Antonio T. Carpio and former Associate Justice Conchita Carpio Morales, as they share their insights on the process of accountability. We also welcome, of course, not only the students of San Beda Alabang, our beloved and happy law school, no less than the Supreme Court and Bank branded this law school as the happiest law school in the universe. But also students from San Beda University College of Law, UP Law, MLQU Law, especially students from UANP Law. Your new president is my son, being a graduate of this institution. I consider students here as my children. So if they have problems, I always tell them, come to Papa and other institutions. So whether joining us on-site or online, you are here not to compete, but to collaborate. While we may hold differing views on this impeachment issue, the path to become a truly great lawyer, as exemplified by Justice Carpio and Justice Morales, begins with openness to new perspectives. It is through thoughtful dialogue that the best solutions emerge. May our time together today be marked by openness rather than rigidity, collaboration instead of competition, and unity over individualism. All this in pursuit of truth, justice, in this significant manner, that in all things God may be glorified. So, again, welcome. I hope you have a good time here, and thank you for your presence. Good afternoon.
Thank you so much, Dean. Our Papa. He is belovedly known as our Papa here at law school. So at this juncture, it's an honor to introduce our main event host for today's program, Attorney Christopher John P. Lau, Master of Laws. Attorney Christopher Lau was born in Davao City. He earned his Bachelor of Arts in Philosophy from the University of the Philippines, Diliman. Graduating summa cum laude and college valedictorian in 2006, he went on to complete his law degree at the same institution in 2011 and was admitted to the Philippine Bar in 2012. Attorney Christopher holds a Master of Laws in Chinese Law from Tsinghua University in Beijing, People's Republic of China. Tsinghua University is ranked first in Asia and 12th globally according to the Times Higher Education. During his time at Tsinghua, Christopher was ranked first out of 159 students in the Juris Master Program and was honored as the 2024 Master of Laws Program Outstanding Student for achieving a perfect 4.0 GPA. Currently, that's impressive. Currently, Attorney Christopher is a partner at the Guzman, Jonido, Cagahucaban and Associates Law Office. He also serves as a law professor at the UP College of Law and at the DLSU Tanyada Jokno School of Law.
Good afternoon, everyone. I warmly welcome you to this special lecture, The Anatomy of Impeachment, a legal deep dive into the accountability process. Today, we are reminded of a simple truth. Public office is a public trust. Accountability is not just a constitutional principle. It is the lifeblood of democracy. Democracy is not just about elections. It is about continuous oversight. Institutions like impeachment, judicial review, audits, and legislative inquiries are designed to ensure that no branch of government becomes too powerful. Accountability makes these checks effective. Without it, democratic institutions are reduced to form without substance. Without accountability, democracy degenerates into mere majoritarian rule, numbers without principles. Accountability gives democracy its moral backbone, the idea that leaders are answerable to the law, to the people, and to history. Again, I am Christopher Lau, and I have the honor of guiding you through today's program. Our discussions today will tackle not just procedure, but also the meaning of impeachment in protecting the rule of law and the integrity of our institutions. Before proceeding further, I would like to acknowledge the presence of the following: Dean Ulpiano Sarmiento III, faculty members of the San Beda Alabang School of Law, retired Senior Associate Justice, of course, Antonio Carpio, retired Associate Justice Conchita Carpio Morales, and former Ombudsman, then Professor Dante Gatmaitan, members of the judiciary, students from different schools of law, San Beda Alabang School of Law, UP College of Law, University of Asia and the Pacific Institute of Law, MLQU School of Law, and the DLSU Tanyada Jokno School of Law. Members of the press, guests and viewers, welcome. To introduce our distinguished guest speaker, I will call on Attorney Joseph Peter Calleja. Attorney Joseph Peter Calleja, simply known as JP to many, is a practicing lawyer at the Guzman Junido Hucaban Law. While at San Beda Law School, Manila, he taught philosophy at the Ateneo de Manila University. Because of his passion in philosophy, he was granted a scholarship at Boston College in Massachusetts, USA, where he took his master's degree in philosophy. JP graduated magna cum laude in philosophy at UP Diliman and was awarded the Best Speaker in the 2013 Carpio Villaraza Cruz Law Debates at ANC. A lawyer for almost 10 years, JP has been handling land dispute cases such as ejectment and titling cases. In 2000, he was handpicked by retired Supreme Court Senior Associate Justice Antonio Carpio to be the spokesperson of Sambayan Coalition, a group of pro-democratic forces that fielded competent candidates in the last elections. He and Justice Carpio, since then, have worked in several high-profile cases that aim to uphold the Constitution, such as the anti-terror law, confidential funds, and PhilHealth petitions. A professor of constitutional law, local government, and public administration, Attorney Calleja believes that changing the nation begins inside the classroom. Ladies and gentlemen, one of our law professors and mentors in the happiest law school in the country, Attorney Joseph Peter Calleja.
Thank you very much, Attorney Lau. It is my honor to introduce this afternoon our guest speaker. Good afternoon, friends, students, guests, fellow lawyers, and law professors, Ombudsman Conchita Carpio Morales, the administration and staff of San Beda College Alabang School of Law, the happiest law school in the country. Many things have already been said about our speaker this afternoon. Apart from the title, the best Chief Justice we never had, many look up to him not only because of his academic background, but his independence, which for him is the most important quality of a member of the judiciary. Justice Antonio Carpio graduated cum laude and valedictorian at the UP College of Law in 1975. He placed 6th in the bar examinations. He earned his pre-law degree in economics at the Ateneo de Manila University in 1970. As a young legal practitioner, Justice Carpio founded the Carpio Villaraza Cruz Law Firm, one of the top and biggest law firms in Philippine history. As managing partner of the firm, Justice Carpio's work ethics was impeccable. It is said that he was the first to open the office and the last to leave to switch off its lights. At 52, Justice Carpio was one of the youngest appointees in the Supreme Court. He brought with him the diligence and excellence from his private practice to the Supreme Court, leaving no backlog in his docket, a feat rarely attained by a Supreme Court magistrate. He penned 935 decisions, 79 dissenting opinions, 30 concurring opinions, 13 separate opinions, and 4 concurring and dissenting opinions. This country owes Justice Carpio, a patriot, for upholding the rule of law and defending the Constitution. I am sure our constitutional law students are aware of his ponencias. In Lambino versus Comelec, the Supreme Court, writing through the wisdom of Justice Carpio, decided that charter change cannot be done by mere people's initiative. In the Lambino case, he wrote, "The Constitution as the fundamental law of the land deserves the utmost respect and obedience of all the citizens of this nation. No one can trivialize the Constitution by cavalierly amending or revising it in blatant violation of the clearly specified modes of amendment and revision laid down in the Constitution itself. by dissenting in the case allowing the former President Ferdinand Marcos Sr. to be buried at the libingan ng mga bayani, Justice Carpio wrote that the People Power Revolution was the strongest form of dishonorable discharge since it is meted by the direct act of the sovereign people. He wrote, "This court has no power to review the legitimacy of the People Power Revolution as it was successfully carried out by the sovereign people who installed the revolutionary government of Corazon Aquino." Lastly, in the quo warranto case against the former Chief Justice Maria Lourdes Pizarreno, Justice Carpio once again dissented and even declined automatic nomination as Chief Justice, despite being the most senior justice at the Supreme Court at that time. Justice Carpio wrote that quo warranto is not one of the ways to remove a sitting justice of the Supreme Court. Today, Justice Carpio continues to defend the Constitution, not as a sitting member of the court, but as petitioner in several high-profile cases that defend the Constitution. A few weeks ago, he, together with Justice Conchita Carpio Morales, constitutionalist attorney Christian Monsod, and our very own, the San Beda College Alabang Human Rights Center, filed a consolidated motion questioning the recent decision of the Supreme Court in the Vice President Sara Duterte impeachment case, junking the articles of impeachment for violating the one-year bar rule, among others. We are gathered this afternoon to listen to his lecture as Justice Carpio navigates in this decision that led retired jurists, academics, constitutionalists, and legal scholars share their thoughts on the impeachment process. Ladies and gentlemen, we wish to present to you our guest speaker this afternoon, Justice Antonio Carpio.
Please be seated. A pleasant afternoon to everyone. Thank you for inviting me to discuss with you this afternoon the Supreme Court resolution on Sara Duterte versus House of Representatives, which was promulgated last July 25, 2025. As you know, Isambayan, which I chair, filed an intervention in this case. That intervention has not been granted yet. But in that intervention, we have to thank also Attorney J.P. Calleja here for he prepared the petition together with Attorney Christopher Lau. We petitioned, we based our petition on two grounds, mainly on two grounds. First, the fourth impeachment complaint was initiated in accordance with the Francisco and Gutierrez doctrine of the Supreme Court. We have our ponente here of Francisco and Gutierrez cases, Justice Chit Morales. And the sequence was as follows. The sequence in the House of Representatives. Before the House plenary convened in the afternoon of February 5, 2025, a resolution of impeachment, which we will call the fourth complaint, signed by 215 members of the House, was filed pursuant to the House impeachment rules with the Secretary General of the House, who verified under oath the fourth complaint. So that was the first step that afternoon. Thereafter, when the House plenary convened at about 3:37 p.m. in the afternoon of that same day, upon motion of Congressman Dalipe, the House plenary voted unanimously to transmit the fourth complaint to the Senate and authorizing the Secretary General to make the transmittal. Thereafter, the House plenary voted to appoint the members of the prosecution panel of the House. Thereafter, the House plenary voted to archive the first three impeachment complaints. In the meantime, the fourth complaint was received in the Senate at about 4:47 in the afternoon of the same day. And at 7:15 p.m. of that same day, the House plenary adjourned. So that was the sequence. Under the then prevailing Francisco and Gutierrez doctrines, the filing with the Secretary General of the fourth complaint, signed under oath by at least one-third of the House members, initiated the impeachment complaint, triggering the one-year bar rule. Thus, the first three impeachment complaints became functus officio, and referral thereafter of any of some or all of the first three complaints to the Committee on Justice would be unconstitutional and a grave abuse of discretion, as explained in the Francisco and Gutierrez rulings. The only recourse of the House then was to archive the first three impeachment complaints. So the House followed faithfully the Francisco and Gutierrez rulings in this impeachment. In the narration of facts of the Supreme Court in their resolution of July 25, 2025, it says, at 4:47 p.m. of February 5, 2025, House Secretary Velasco transmitted the articles of impeachment to the Senate without a plenary vote. Let me repeat that. At 4:47 p.m. of February 5, 2025, House Secretary Velasco transmitted the articles of impeachment to the Senate even without a plenary vote. Clearly, this is contrary to what happened. The House plenary voted unanimously to transmit the fourth complaint to the Senate. The fourth complaint was initiated well ahead of any plenary action on the first three impeachment complaints. The initiation of the fourth complaint, whether counted from the filing with the Secretary General following the Francisco and Gutierrez ruling, or counted from its approval by the House plenary following the new requirement of the Supreme Court in the resolution of July 25, 2025, whether you count the initiation based on the then prevailing Gutierrez and the Francisco rulings, or under the present Supreme Court resolution, what was initiated was the fourth complaint. And because the fourth complaint was initiated, the first three impeachment complaints had to be archived. Thus, it was the initiation of the fourth complaint that triggered the running of the one-year ban rule, preventing the first three complaints from being referred to the Committee on Justice, because in the Francisco and Gutierrez rulings, the court said if a complaint has already been initiated, you cannot file another impeachment complaint within 1 year period. So what do you do with the complaints that have already been submitted to the plenary? You have to archive them. You cannot refer these pending impeachment complaints to the Committee on Justice, because that would violate the Constitution. Now, the glaring error of the SC resolution that the fourth complaint was not initiated. It was the first three impeachment complaints that were initiated. This error led the Supreme Court to erroneously conclude that the fourth complaint was not initiated, and that the House committed a grave abuse of discretion in archiving and not referring the first three impeachment complaints to the Committee on Justice. The SC resolution ruled that it was ministerial on the part of the House to refer the first three impeachment complaints to the Committee on Justice. However, under the Francisco and Gutierrez rulings, any referral of an impeachment complaint to the Committee on Justice after an impeachment complaint had already been initiated under the second mode of impeachment would be unconstitutional and a grave abuse of discretion. So the Supreme Court said in Francisco and in Gutierrez, if there is already an impeachment complaint that has reached the Committee on Justice, any referral of the impeachment complaints that have been left in the plenary, any referral of those complaints to the Committee on Justice would now be unconstitutional because the one-year bar started to run. When one impeachment complaint reaches the Committee on Justice, then the one-year bar starts to run. Any referral of an additional complaint to the Committee on Justice would be a violation of the Constitution and would constitute grave abuse of discretion. Now, as of February 5, 2025, the prevailing doctrine was, as laid down in Francisco and Gutierrez, that an impeachment under the first mode is initiated for the purpose of triggering the one-year bar rule when the impeachment complaint is referred by the House plenary to the Senate Committee on Justice. So that is the triggering point of the one-year bar rule. When an impeachment complaint reaches the Committee on Justice, the one-year bar rule starts to run, and you cannot send another impeachment complaint to the Committee on Justice. That's under the first mode, no? Under the second mode, the impeachment complaint is initiated for the purpose of triggering the one-year bar rule when the impeachment complaint, signed under oath by at least one-third of the members of the House, is filed with the Secretary General of the House. Under the House rules, if you do a direct filing means one-third of the members of the House will file the impeachment complaint. You have to file it with the Secretary General of the House. And Gutierrez and Francisco said that is the triggering point. When one-third of the members of the House filed that resolution of impeachment with the Secretary General, the one-year bar rule is triggered under the second mode because there are two modes for impeachment. The first mode is when an ordinary citizen files an impeachment complaint endorsed by a member of the House, or a member of the House will file that directly by himself. That's the first mode. The second mode is when one-third of the members of the House will file directly with the Secretary General a resolution of impeachment. Now, the fourth complaint in this case against Sara Duterte complied with the then prevailing SC doctrine as laid down in Francisco and Gutierrez, because the impeachment complaint signed by at least one-third of the members of the House were filed with the Secretary General, and therefore the one-year bar rule started to run. But the Supreme Court said in their resolution, they said they amended the Francisco and Gutierrez doctrine by saying that that the impeachment complaint under the second mode must have an additional requirement. And that requirement retroacts. The Supreme Court said under the second mode, it is not sufficient that one-third of the members of the House will file it with the Secretary General. The draft articles of impeachment must be given to the respondent official, and the respondent official will be given an opportunity to be heard at the plenary level. So the new Supreme Court requirement under the resolution of July 25, 2025, added this requirement. It is not sufficient that the articles of impeachment signed by at least a third of the House is submitted to the Secretary General. You must first give a draft of the articles of impeachment to the impeached official, and he or she must be given an opportunity to be heard at the plenary level. This is a new requirement. Thus, the SC resolution now requires, inter alia, that under the second mode, the House must provide the respondent official with the draft articles of impeachment, and the respondent official must be given an opportunity to be heard on the draft articles of impeachment at the plenary level. This additional requirement clearly contravenes the second mode in Article 11, Section 3.4 of the Constitution, which provides, and I quote, "In case the verified complaint or resolution of impeachment is filed by at least 1/3 of all the members of the House, the same shall constitute the articles of impeachment, and trial by the Senate shall forthwith proceed." Let me repeat that. The same shall constitute the articles of impeachment, and trial by the Senate shall forthwith proceed. In impeachment, the final product in the House is the articles of impeachment. Whether it's in the first mode or in the second mode, the final product is the articles of impeachment. This provision of the Constitution says, if 1/3 of the members of the House sign the verified complaint or resolution of impeachment, the same shall constitute the articles of impeachment. It's a shortcut. You do not have to have hearings anymore if 1/3 of the House signed the articles of impeachment. Once the impeachment complaint is filed by at least 1/3 of the House members, the impeachment complaint ipso facto becomes the articles of impeachment without any further action or intermediary step, and trial by the Senate shall forthwith proceed. Forthwith means kaagad. In the Filipino official version of the Constitution, forthwith is translated as kaagad, immediately. Any further action or intermediary step, like a hearing at the plenary level, violates the letter and intent of Article 11, Section 3.4 of the Constitution. And that has been the understanding of everyone. By the framers of the Constitution, by those who decided Gutierrez versus House of Representatives, or Francisco versus House of Representatives, and those who filed the impeachment complaint in the Estrada and Corona impeachment complaints. That has been the understanding. That if it's the second mode, once the articles of impeachment are signed by at least 1/3 of the members of the House, then that's it. There is no intermediary step. The same shall constitute the articles of impeachment, and trial by the Senate shall forthwith proceed. There's no other action to be done. That has always been the interpretation by the framers of the Constitution and by the members of Congress, members of the Supreme Court. But in the July 25, 2025 SC resolution, the court said there is an intermediary step. You have to give the respondent official an opportunity to be heard at the plenary level. Worse, the SC resolution made its new additional requirement retroactive to February 5, 2025. No one in the world, not even the members of the Philippine judiciary, until the SC resolution came out last July 25, 2025. No one in the world, not even the members of the judiciary, knew that the respondent official is entitled to a hearing at the plenary level under the second mode of impeachment. What everybody knew was that once the impeachment complaint or resolution of impeachment is filed by at least one-third of all the members of the House, the same shall constitute the articles of impeachment and shall immediately be transmitted to the Senate for trial to proceed forthwith. It is at the Senate that it is at the Senate trial that the impeached official will be afforded an opportunity to be heard. So this is really a new requirement. The fundamental and universal due process rule is that no one is bound to comply with a non-existing rule. One is bound to comply with a rule only if he has constructive or actual notice of a rule. Constructive notice exists if the rule has been duly published, whether you read it or not, you are bound. And actual notice exists if one has been personally given a copy of the rule. Then you are bound, of course. On February 5, 2025, when the House plenary voted to transmit the fourth impeachment complaint to the Senate, the House could not possibly have known constructively or actually, and thus could not have been bound by the new additional requirements imposed by the SC resolution, which was released only on July 25, 2025, almost 5 months after the February 5, 2025 the date when the impeachment complaint was filed. No? In summary, there are two takeaways here. No? First, it cannot be denied that factually it was the fourth impeachment complaint that was initiated on February 5, 2025, not the first three impeachment complaints. This is borne out by the official journals of the House. The SC is bound, the Supreme Court is bound to take judicial notice of House journals, not media reports. Thus, the first three complaints, not the fourth complaint, were barred under the one-year rule of the Constitution. When the impeachment, articles of impeachment was signed by at least one-third of the members of the House and submitted to the Secretary General, that triggered the one-year bar rule. What were barred? The first three impeachment complaints. But the SC resolution takes it backward. It is the fourth complaint that is barred by the first three. But what was first initiated? The fourth complaint or the first three complaints? Very clear from the journals of the House. It was the fourth complaint that was initiated. Thus, the first three complaints, not the fourth complaint, were barred under the one-year rule of the Constitution. Contrary to the narration of facts of the SC resolution, the fourth impeachment complaint was indisputably voted upon unanimously by the House plenary. This is borne out by the House journals and cannot be denied. So when the Supreme Court said in their resolution, the fourth impeachment complaint was transmitted even without a plenary vote, that's totally contradicts the records. And there was even a video by ABS-CBN of the plenary voting on the fourth impeachment complaint. The second takeaway is that the House merely followed the then prevailing Supreme Court doctrine as embodied in Francisco and Gutierrez. When the House initiated the fourth complaint on February 5, 2025, they followed faithfully Francisco and Gutierrez. There can be no grave abuse of discretion when you faithfully follow the then prevailing Supreme Court decisions. How can you be in grave abuse of discretion when you just follow the Supreme Court? But yet in this SC resolution of July 25, 2025, the Supreme Court said there was grave abuse of discretion by the House when they transmitted the fourth complaint to the Senate. How can there be grave abuse when you are following the Supreme Court? If the Supreme Court changes its doctrine, then the new doctrine should apply prospectively, not retroactively, to strike down a prior act that, when it was performed, had complied faithfully with the then prevailing Supreme Court doctrine. This is why we have the doctrine of operative fact, also called the doctrine of prospective overturning. A new judicial doctrine cannot be applied retroactively if to do so will make an act perfectly valid and constitutional at the time it was performed based on the then prevailing judicial doctrine, but made invalid and unconstitutional by applying retroactively the new doctrine. That's against all common sense. Such new doctrine should only be applied prospectively. Thus, the SC gravely erred when it ruled that the House committed grave abuse of discretion when it did not provide Sara Duterte an opportunity to be heard at the plenary level, a new requirement that was not present in the Francisco and Gutierrez rulings or even in the Estrada and Corona impeachment procedures. Even so, the new requirement of a hearing or opportunity to be heard at the House plenary level for the second mode of impeachment violates the letter and intent of Article 11, Section 3(4) of the Constitution, which does not provide any further action or any intermediary step once a verified complaint or resolution of impeachment is filed by at least 1/3 of all the members of the House. Once there is a resolution of impeachment signed, verified by 1/3 of all the members of the House, the Constitution says the same shall constitute the articles of impeachment, and trial by the Senate shall forthwith proceed. There is no intermediary step anymore. So these are our arguments that we presented at before the Supreme Court, but our petition for intervention is still pending. But let us go through together with the decision of the court, the resolution of July 25. Can you bring it up? Yes, some more. Go to the page where there is a highlight. Some more. Please scroll some more. The first highlight. Okay. The court says here, all legal issues involving impeachment proceedings are subject to judicial review. This raises a red flag right away. All legal issues involving impeachment proceedings are subject to judicial review. My take is, and this has been the understanding ever since, the Supreme Court can intervene in an impeachment case only if there is a violation of a specific provision of the Constitution, violation of a specific provision of the Constitution, or there is a grave abuse of discretion amounting to lack or excess of jurisdiction. So it has to be a constitutional conflict. But the Supreme Court is now saying any legal issue, whether constitutional or statutory, will allow the Supreme Court to intervene. Now, in the resolution, the Supreme Court said the standard of evidence, the quantum of evidence required to convict in an impeachment case is clear and convincing evidence. This is the first time that there has been a rule laid down. In the U.S., in impeachment cases in the U.S. where we copied our impeachment procedure, there is no standard of evidence. There is no quantum of evidence that's required because it is up to the collective wisdom of the Senate whether to convict or to acquit. But here, it has been made a legal issue by the Supreme Court. So if you have been convicted by the Senate in an impeachment case, you can now go to the Supreme Court. It is now subject to judicial review. You can say there is no, the prosecution did not meet the quantum of evidence, which is clear and convincing evidence. So decisions now of the Senate Impeachment Court is now appealable to the Supreme Court because all legal issues shall be subject to judicial review, all, without exception. The Constitution says the Senate shall have the sole power to try and decide impeachment cases. To decide means to decide whether it's acquittal or conviction. But that is now subject to judicial review. The person convicted can go to the Supreme Court. There is no sufficient evidence because the standard is clear and convincing evidence. He can now question his conviction. The Senate now doesn't have the sole power to try and decide because they are now subject to review by the Supreme Court. This is the meaning of that. Can you... Next, okay. Within these periods, the House may opt to consolidate all impeachment complaints properly commenced. This refers to impeachment complaints under the first mode. Let us say 3 impeachment complaints were filed. The Supreme Court is saying the plenary, House plenary, can opt to consolidate and may also opt not to consolidate. If it does not opt to consolidate, it will have to decide on one, whether it's the first one, second, or third one, it can choose. Because under Francisco, the court said the first to file rule is not correct. The plenary can choose. If there are 4 impeachment complaints, the plenary can choose which one to act first, to be acted on first. And so if the plenary can choose one, whether it's the first, second, or third, and sends that to the Committee on Justice, the 1-year bar rule takes effect. The rest of the impeachment complaints at the plenary level will have to be archived. Because if you bring it up to the Committee on Justice, that will violate the 1-year bar rule. And that's the decision in Gutierrez and Francisco. So the Supreme Court is saying here, there is an option by the plenary, and this is correct. But down later on, the Supreme Court will say, will contradict this. Can you proceed? Now, the Supreme Court said that in the 19th Congress, that's the last Congress, not the present 20th, the 3 impeachment complaints became unacted upon. Since these complaints were archived, they were effectively terminated and dismissed. If they were archived, it was acted upon. Archived. Why were they archived? Because there was already an impeachment complaint that took effect. The 4th impeachment complaint, which was a direct filing signed by 1/3 of the members of the House, already initiated one impeachment. So you cannot initiate any other within a period of 1 year. So that's why they did not act on it. In other words, they archive it. They did not bring it up to the Committee on Justice because you cannot bring it up to the Committee on Justice. The 1-year bar rule has taken effect. But the Supreme Court interpreted it differently. We will look at that later. Go ahead. Scroll. Now, the Supreme Court is saying that The one-year bar rule is reckoned from the time an impeachment complaint is dismissed or no longer viable. So the Supreme Court now is saying, because the plenary archived the first 3 impeachment complaints, it triggered the one-year bar rule. Okay, let's examine that. What is the purpose of the one-year bar rule? The purpose of the one-year bar rule is so that the public official will not be subjected to several suits that will harass him. He will not be subject to harassment of multiple impeachment cases. But if you dismiss the 3 were dismissed, how could you say that the one-year bar rule applied? Because there was no harassment. In fact, the first 3 were dismissed. So the Supreme Court said, because they were dismissed, the one-year bar rule took effect. That's the complete opposite of the rationale behind the one-year bar rule. The one-year bar rule applies when the impeachment reaches the Committee on Justice, because from there on, you have to defend yourself. There will be a hearing. You have to present your evidence at that point. But here, the Supreme Court is saying, because it was dismissed, the one-year bar rule took effect. If I were the public official, I would keep on filing weak cases that will be dismissed. There will be a one-year bar rule every time it's dismissed. So it doesn't make sense. Okay, please scroll. Okay, here it is. Under the second mode, the direct filing, can you bring it down a little? We'll see. So this one refers to the direct filing. Can you bring it down? Okay. The evidence should be sufficient to prove the charges. If it's not sufficient, if the person being impeached feels it's not sufficient, he can now go to the Supreme Court. Okay. Here again, impeachment is an act of the entire House which requires a qualified minority vote of only 1/3 of its members to be transmitted to the Senate. But if you look at Article 11, Section 3(4), it says, if the verified complaint or resolution of impeachment is signed, is filed by at least 1/3 of all the members of the House, the same shall constitute. It is an act only of 1/3. It's not the act of the entire House. And that has always been the interpretation before this July 25 resolution. But the Supreme Court is saying now, it has to be the entire House that will vote. And 1/3 will be sufficient. Okay. Can you please? So now you have to show the draft articles of impeachment and supporting evidence at the plenary level. The House does not operate at plenary level with investigations. They always have committees. So the rule is the House operates through committees. Committee of Justice, that's for impeachment cases and others. Because it will be too unwieldy for 315 members to be investigating. That's why you have all of these committees. But now, the resolution says it will have to be the House that will conduct a hearing. That's against the tradition, the practice of the House. They always act through committees. They declare the plenary as a committee of one in very rare instances when they have, for example, they don't want to send back a committee report to the committee. They will just, because it will be very easy to amend the committee report, or in the last example is during the when when there was a proposal to amend the Constitution, whether by people's initiative or by Constituent Assembly, they called a committee. They declared the entire plenary as a committee of one. But that was not an investigation. They just asked resource speakers to express their views. But when it comes to investigation, they almost always send it to a committee. But here the Supreme Court is saying the plenary must constitute itself into an investigating committee. That will take a lot of time. Can you bring it up? Okay, this is another new element. The charge must be for an impeachable act committed in relation to their office during the current term of the impeachable officer. This is a new doctrine. In the U.S., an impeachable officer can be subject to impeachment for acts committed before he assumed that office, where he's that is subject, where the holder is subject to impeachment. Why? Very important. Let us say, because we have Congress now being investigated, there is a congressman who was elected president. Say he will be elected in 2028 as president. And then suddenly everybody realized through investigation that he had flood control projects, ghost flood control projects. So what will happen now? He cannot be impeached because the act must be committed in relation to his current office. So we will have a plunderer as president and we cannot do anything. Another example, and it can happen. We have a president who, before he became president, was an agent of China. He gave secrets to China when he was not yet a president. It was discovered when he was already a president. He cannot be impeached for betrayal of public trust because it was not committed during his term as president. It's very dangerous doctrine. In the U.S., you can be impeached for acts committed before you assumed your presidency or before you became a justice of the Supreme Court. This is a new doctrine. It's not, I don't think we should be adopting it, but the Supreme Court, out of the blue, this is not even an issue. This is just obiter, according to Justice Vic Mendoza. Oh, that's an obiter. But we have to discuss this because this is very dangerous. Can you? Okay, this is now under the second mode. You are now required under the second mode, direct filing, to provide a copy of the draft articles of impeachment, and the person being impeached has an opportunity to respond within a receivable period to be determined with the House rules. Right now, the Constitution says, under the second mode, if the verified complaint or resolution of impeachment is filed by at least one-third of all the members of the House, the same shall constitute the articles of impeachment, and trial by the Senate shall forthwith proceed. Now, the Supreme Court is putting an intermediary step that you must give a copy of the draft articles. So that means the members of the House cannot sign the articles of impeachment, even under the second mode. They have to first give a copy to the person being impeached, and that person being impeached has a right to defend himself at the plenary level. That is not direct filing. That's not the express lane that the framers of the Constitution envisioned. Because the due process requirement happens at the Senate level. At the trial in the Senate, that's where you defend yourself. But here, the Supreme Court is injecting an intermediary step that has never been envisioned by anyone before. Can you? And the Supreme Court is even saying there must be a modicum of deliberation. In this case, what happened was that there was a motion by Congressman Delipe that the fourth impeachment complaint be approved by the House. No objection. This SC resolution says that is unconstitutional. There must be some modicum of deliberation. How can you force them to make a discussion if they all do not object? Okay, can you go up? So that's why the Supreme Court said, because you did not give a copy to Sara Duterte of the draft articles of impeachment under the second mode, it is null and void. A new requirement that is being applied retroactively. Okay, can you move up? Okay, this is a question of fact. The potential says, the resolution says, House Secretary Velasco transmitted the articles of impeachment to the Senate even without a plenary vote. Totally wrong, factually wrong. It is contradicted by the video of ABS-CBN, by the journals, and by the people there who voted. But because of this is not a footnoting problem only. Because from this, the Supreme Court concluded the fourth complaint is void. Therefore, there is no impeachment complaint that bars the other three. The other three will bar this fourth complaint. It leads now to the erroneous conclusion that the first three complaints should be considered as having been terminated, and therefore the one-year bar period starts to run. Can you bring it up? Some more. Okay, some more. Please bring it up. Okay, can you go back to that? The Senate says, the SC resolution says that on February 5, 2025, when they adjourned, there was nothing that could be done anymore because of the adjournment. Wrong. Because it was not a sine die adjournment. A sine die adjournment happens only at the last session when the term of the Congress expires. And it will expire only on June 13. Congress adjourns sine die. Any adjournment before that is only a recess. It's just a break. And remember, the Congress, the plenary, the House plenary, must include the complaint within 10 days from the time it is filed and refer it to the Committee on Justice within three session days. So on February 25, when they adjourned, there were still session days because they will still meet on June 2, and they will adjourn only on June 13. So that was an error again. Can you bring it up? Okay. Bring it up. Some more. Okay, some more. Okay. Okay, this is what I said before, that the plenary is allowed to choose among, let's say, 4 impeachment complaints, which one to tackle first. And if they approve that, it's sent to the Committee on Justice, and the 1-year bar rule runs. And all the rest of the impeachment complaints will have to be archived. Why archive? Because it cannot be sent up, because that will violate the 1-year bar rule. And that's exactly what happened here. When the 4th complaint was filed with the Secretary General, that was the initiation. The 1-year bar rule started to run. That's why you have to archive the other 3. That was the reason. Okay, bring up. Okay, these are the issues. Whether the House of Representatives committed grave abuse of discretion when it verified. The Supreme Court said, yes, it committed a grave abuse of discretion because they did not give a copy, the draft of the articles of impeachment, to VP Sara. And second, the 4th complaint was barred already. But of course, it was not barred. It was the complaint that was acted upon, and it barred the other 3. Okay, we can go up. The SC resolution quotes a decision of a court. What is the meaning of grave abuse of discretion? When there is a gross misapprehension of facts. It was the court that committed a gross misapprehension of facts when it said that the 4th complaint was transmitted even without a plenary vote. There was a plenary vote. The court quoted ABS-CBN report. And that report even said there was a plenary vote. Okay, go up. Go up. This is Francisco. A complaint is deemed initiated upon the filing and referral or endorsement of the House to the House Committee, or by the filing of at least 1/3 of the members of the House. By the filing of at least 1/3. To whom do you file it? Under the House rules, you file it with the Secretary General. So that is the initiation. And it was initiated at that point. See, the court is saying there must be clear and convincing evidence before you convict. So if there is none, what will happen? The impeached official can go to the Supreme Court. Go up. This is correct. Again, that's in the Constitution, and that's in Gutierrez and Francisco. Go up. Okay, this is the procedure. There is actually in the Committee on Justice, what will be decided will be if impeachment complaint sufficient in form? Is it sufficient in substance? And is there probable cause? If there's probable cause, the copy of the impeachment complaint will be given to the impeached official, and there will be a hearing. And the impeached official can present evidence on his behalf. Go up. Okay, some more. Okay, go up. Okay, go up, go up. Again, the Supreme Court is saying the acts have been committed during the incumbency of the respondent. Okay, I think it's time for me to end here. Thank you for your patience and kind attention.
So thank you so much, Justice Carpio. We learned so much, correct? So let's, of course, give Justice Carpio our sign of appreciation. So I'm very excited because we have already received some questions online. So we'll get to that later on. But right now, we will proceed to our panel discussion to further deepen our understanding and engage with different perspectives on this vital topic. It is my distinct honor to introduce our panel reactor for today's session, Professor Dante Gatmaitan, a distinguished constitutional law scholar and educator whose work continues to shape legal discourse in the Philippines. Professor Gatmaitan is a professor, George A. Malcolm Professor of Constitutional Law at the University of the Philippines College of Law. He earned his Bachelor of Science in Legal Management from the Ateneo de Manila University in 1987, followed by his Bachelor of Laws from the University of the Philippines in 1991. He took further legal studies, earning master's degrees from Vermont Law School, Master in Environmental Law, cum laude, and the University of California, Los Angeles, UCLA Master of Laws. Before entering academia in 1998, Professor Gatmaitan practiced law through public interest law offices, working with rural poor communities on issues related to environmental and natural resources law, indigenous peoples' rights, agrarian reform, and local governance. His scholarly contributions are extensive and impactful. Professor Gatmaitan has authored several books, including Legal Method Essentials, my prescribed book in my class, Local Government Law and Jurisprudence, Constitutional Law in the Philippines, Government Structure, More Equal Than Others, Constitutional Law and Politics, and Underclass, Public Interest Law Practice Perspectives. His research interests encompass constitutional amendments, interaction of law and politics, and comparative constitutionalism. His works have been published in reputable journals such as the Asian Journal of Comparative Law, UCLA Pacific Basin Law Journal, and the Harvard Women's Law Journal. In addition to his academic and professional achievements, Professor Gatmaitan has served as the head of the Information and Publication Division of the UP Law Center from 2013 to 2018 and is currently the director of the Institute for the Administration of Justice. Today, Professor Gatmaitan has found his new passion in education by not necessarily being inside the classroom. Social media and the internet are now his classroom as he co-hosts a daily YouTube show with his wife, economist and former Undersecretary for Fiscal Policy and Monitoring of the Department of Finance, Professor Shelo Magno. Please join me in welcoming Professor Dante Gatmaitan.
Hi, thank you. Good evening to everyone. Justice Carpio, Justice Conchita Carpio Morales. It's been Sarmiento Taylor, yeah. Right. And to everyone, we've been thanking everyone all day. So let's get started. I think the best part about being a reactor is that I cannot take more time than the person who delivered the lecture. So relax. I want to thank Justice Carpio. Of course, he has laid down or he has explained the weaknesses of the Supreme Court's resolution of July 25, 2025. And like the motion for reconsideration filed by the House, both raise factual errors, right, upon which the court's resolution was based. And therefore, I do not envy the Supreme Court because it will be difficult to wiggle out of this situation where apparently they got the facts wrong. And if you have the facts wrong, you cannot possibly have a just resolution of the case. So what's going to happen? Since you cannot ignore the facts, I suspect the camp of the Vice President would invent new facts or ignore the ones that have been brought up in the motion for intervention as well as the motion for reconsideration. Now, if we had an opportunity to look at the comment filed by the Vice President, the comment to the motion for reconsideration filed by the House, there's a theme that runs through it that is very unsettling. Because like the motion for intervention, it raised certain the factual errors. And yet, if you read it, they make certain statements like the following. These claims are mere diversions, obsessed with trivia, and blind to the decision's genuine core reasoning. I'm quoting from the comment. They fixate on immaterial details that do not alter the substance of the decision. And one more, it is clear from the decision that the determination by this court that the fourth impeachment complaint violated the one-year ban rule rested not on this incidental sequential detail, but on substantive legal grounds. So the strategy seems to be to de-emphasize the facts and focus on what they call the core ruling. Never mind trivia. Do not obsess with tiny details. Let's look at the real stuff. And by real stuff, they mean that I think that the first three impeachment complaints, because they were not acted upon, actually triggered the one-year ban. And that is the thing that drives us crazy. Diba? Well, it drives me crazy. When the decision first came out, I think most of us asked the question, how can impeachment complaints that were never initiated trigger the one-year ban? And as Justice Carpio pointed out, well, here's what they're arguing now. That the inaction itself, the refusal to refer the three impeachment complaints triggered the one-year ban. The inaction is an action by itself. And here's the difficult part to swallow, diba? And by refusing to initiate, by referring it to the proper committee, they in effect initiated the first three. Diba? I don't want to comment on the logic. I'm telling you what I read, and you can make your own conclusions. Next. There cannot be any vote on the plenary because they did not follow the rules of the House on how to vote. And by that, the camp of the Vice President said, you must follow the script that is laid down in the House rules on impeachment. So the Speaker has to rise, and say things like, those who are in favor say aye, those who are against say nay. And the problem, according to the camp of the Vice President, is that the Speaker did not do that, and the Speaker simply said, are there any objections? To many of us, that probably qualifies as substantial compliance. Diba? This is not a constitutional text. It is the rules of the House on impeachment, and the Supreme Court has said on several occasions they can change their rules anytime they want. But the underlying theme again, and throughout this initial resolution, I think is the humiliation of the House of Representatives. In that the court seems to say, and all these details about all these requirements for due process are premised on the inability of the members of the House to understand the thing that they're signing on to. Did they vote, or their inability to make an informed decision because they were not given enough time to discuss this matter? Diba? Did you give them a copy? Did you give them evidence? Did they have enough time? Did you give them a space to discuss? None of which we can none of which are in the Constitution, and none of which, for example, we can demand of the Supreme Court. If it were the other way around, then we ask, and don't do this, don't ask a justice, when you voted on this decision, did you really understand it? Did you have enough time to read it? Were you given a copy? Diba? Or did the ponente simply ask, are there any objections? But that is the effect of what the Supreme Court did in this resolution. On the pretext that there was a denial of due process, the Supreme Court was saying they might not have understood what they were doing. Next. Even assuming that there was a vote, they said, the problem are my glasses, I think, sorry. Even assuming, arguendo, that a plenary vote was in fact conducted, such circumstance does not ipso facto establish that the court committed any material factual error, justifying reconsideration of the decision on that ground. What is plain from the decision, absent any tendency to nitpick on inconsequential details, is that in the course of narrating events, the court merely noted a contemporaneous news report on the transmittal of the fourth impeachment complaint, which again was neither the sole nor decisive basis for its ruling. So, the court didn't do anything wrong, it just noted something that it found on the news. There. Again, here further, they're arguing the House of Representatives' failure to refer the three impeachment complaints to the proper committee, coupled with the Secretary General's unjustified delay in immediately endorsing them to the Speaker in accordance with the House rules, constitutes an initial action. This in turn operates as initiation of the said complaints, and with the expiration of the 19th Congress, effectively dismissed. So this is how they are going to argue that the fourth impeachment complaint is actually unconstitutional. Because by not acting on the first three, you have initiated them. Next, just a note, because I promised to be short. I have to say something about operative fact on the application of new doctrines. They will cite cases that say you can immediately apply a new ruling, but the weight of authority is the opposite, and that you cannot fairly require a party to comply with rules that are changed by the Supreme Court. Diba? I think there was a case, party list, where the Supreme Court said, of course, COMELEC did not. When they changed the formulation ng party list, of course, the COMELEC did not abuse its discretion because it merely followed our rulings before. Okay? So you don't penalize them. And yet, in this case, somehow, it's abuse of discretion. And on due process, there are cases, of course, that say due process must be made available to a respondent or a defendant from beginning to end for the entire proceeding. So even after conviction, diba? But the problem there is, as Justice Carpio said, there is already a built-in system by which the respondent in an impeachment case can defend herself, and that is through trial. And even if you say, well, there's nothing wrong with requiring due process all throughout the process of impeachment, but there would be if it has the effect of amending the Constitution. And if you require due process at the plenary level, if it has the effect of slowing down or rewriting the forthwith requirement, then that cannot be done. You cannot just insert. And one last thing, and all these due process discussions given by the Supreme Court, I would argue, yes, that it's arbiter. So unless they are made in response to an issue that was raised, we all start treating it like it's obiter dictum, therefore it's not doctrinal. Okay? It does not create doctrine. Good. And those are my comments. I'd like to thank all of you, and good evening.
Thank you for comprehensively enriching that lecture, our lecture, Professor. So, thank you so much for our panel and our speakers for these insightful presentations. We now open the floor for the open forum. Now, this is your opportunity to ask questions, share your thoughts, and seek clarification from our panelists. Please raise your hand or use the chat function in Zoom if you have any questions. And the floor is open. The mic is there for any of you who want to ask your questions. And we'll do our best to get to as many as time allows. We encourage respectful and thoughtful participation, so please keep your questions concise and relevant to the discussion. With that, the open forum is now officially open.
May we invite Justice Carpio and Professor Gatmaitan to the stage. So we already have questions from social media, so maybe we begin with these questions. These are very good questions. Justice. So the first question is from social media. Why file a motion for reconsideration if the present decision says another impeachment complaint may be filed no later than February 2026?
Well, because first of all, there are serious factual errors in the decision. That's one. Second, the Supreme Court is saying that the House should amend its rules to include the 7 items that in case of the second mode of impeachment, they must give the person, the respondent, a copy of the draft of the articles of impeachment, and that person has the right to a hearing at the plenary level. That's completely contrary to the Constitution. So, I mean, you have to correct this now. Thank you.
Yes,
Professor? Thank you, Justice.
Is this on? Is it on?
It is on.
Okay. The question is not whether there's another opportunity to impeach the Vice President. It's a question of whether the Supreme Court's resolution of July 25 makes sense. And if it's wrong, both in fact and law, then it's a responsibility to make sure it is reconsidered.
Thank you, Professor. Now, anyone from the audience would like to ask our speakers? Yes, sir.
Good evening. I am Aldrin from UP College of Law. My question is, prior the filing of the impeachment complaints, there were various hearings in the House already. And it was on these hearings where the Mere Grace Piatos came out to public. Can we not consider these hearings as due process? And while I understand that from the perspective of the judiciary, it may not count as due process, but we're talking about the legislative branch, which may, I understand, may have a different process.
Well, the Quadcom hearings elicited certain facts, no? And that's why those facts were included in the articles of impeachment. But, of course, the impeached official is entitled to a proper hearing. And that proper hearing really is, if it's under the first mode, there's the Committee on Justice, where he has a right to present his evidence. And if it's in the second mode, there's the Senate. You still have to follow the Constitution. You cannot dispense with the proper hearing. But there is no hearing at the plenary level. I mean, that's the House does not operate by declaring the entire House as a whole as the investigating body. They have to operate through investigating committees. Thank you.
The Quadcom hearings are not adversarial or disciplinary. So I think it doesn't constitute a due process for purposes of the impeachment because there is no such impeachment case yet.
Thank you. Thank you.
Does anyone else have a question? Please raise your hand. And so we go to the question submitted online. Is there any connection between the impeachment process and the extrajudicial killings allegedly committed by the Dutertes?
Well, there's none, I think, in the articles of impeachment that injects the extrajudicial killing. I don't know. I haven't seen that anything like that.
I seem to remember something, but I'm not sure, so I'm not going to say anything else.
Okay. Other questions? Please state your name and your school or your affiliation.
Good afternoon. I'm Eliza from UP College of Law. I would like to read this part from the decision. The decision is immediately executory. The decision is immediately executory. After the decision was released, the senators actually weighed in on this word, and they said the decision is immediately executory, so we have to follow it. Can you comment on the propriety of this basis used by the senators?
Well, the Supreme Court does issue decisions saying it's immediately executory, but it doesn't mean it is final. What is important is whether it's final or not. If it's not final, you can file a motion for reconsideration. If it's executory, that means that what is being restrained or what has been stopped can continue to be done. In the case of the Senate, they just archived it, which I think it's okay because if it's archived, it's not dismissed. The problem if it were dismissed and the Supreme Court it reverses itself, what do you do now? So I think the archiving was okay. Thank you.
It's the same thing.
Thank you.
Anyone else who wishes to ask our experts? Yes, sir.
Hi, Justice. Currently, we have 3 complaints of impeachment that has been archived in the Congress. And being archived, as I agree with you, it is not currently dismissed. Can the Congress still use these complaints to open up a new articles of impeachment to be initiated by the Congress?
Yes, the Supreme Court resolution of July 25, 2025 says that the same impeachment complaint can be refiled on or after February 26, I think, 26, 2026. So it can be refiled after the 1-year ban. Any of the 4 can be refiled after the 1-year ban.
On a follow-up, Justice, over the first 3 complaints, we've noticed that the Congress didn't act on the impeachment complaints. And would you think there is a possible remedy to create a level of compulsion for the Congress to actually perform their duties in transmitting the complaint from Congress to the Senate?
Well, if you read the articles of impeachment, the 4th and the first 3, all these essential elements in the first 3 are already in the 4th. In fact, all congressmen who endorsed the first 3, except 1, endorsed also the 4th complaint. So actually, although the decision says that these are two separate, they were filed under 2 separate provisions. The first 3 were under the first mode. The 4th was under the second mode of initiating impeachments. The 4th complaint actually took out all the important elements in the first 3. And that was really the intention, I think, of the congressman who formulated the 4th complaint, to come out with a very strong articles of impeachment.
So,
Thank you.
would you say, Justice, that the 4th complaint consolidated the first 3 impeachment complaints?
Well, effectively, although this resolution says they are separate because of the first 3 were under the first mode and the 4th was under the second mode. But remember, even if there are a dozen impeachment complaints under the first mode, the moment there is a resolution of impeachment signed by at least 1/3, that automatically supersedes everything, provided not a single one has reached the Committee on Justice, because the moment one of those dozens reaches the Committee on Justice, then the 1-year bar rule applies.
Thank you, Justice.
Thank you.
Other questions?
Good evening, Justice. I'm Jose Marie Miguel Gambe from the UANP Institute of Law. My question is just more directed on the weight of the decision. So it was an en banc decision, and it was unanimously decided upon by the Supreme Court and agreed. So my question is on, has this been done before? Can a unanimous en banc decision, has this been done in the history of the judiciary? And if not, how can it be done now, given the weight of the decision itself?
I think there is at least one example where the Supreme Court reversed an en banc decision. I think that had to do with genetically modified organisms. Yung tanong yan, no? The tanong, okay, that's okay. Yes, so it's been done. Pero I want to emphasize that, remember here, you don't need 13 votes. You only need 8. Diba? So a lot of people are suggesting that it's near impossible because you can't get 13 justices to change their mind. You need 8. That will be a majority. In fact, my theory is that you can have 6 and have the 2 justices who didn't vote before participate. I'm not sure if that's legal. But I might as well ask. Diba? I have a question. Justice. When a justice was on leave or for whatever reason did not participate during the first round of voting, can they vote again on a motion for reconsideration?
Yeah, depends on the reason why he wasn't able to vote in the first. If he was on leave because he was sick, then he can vote again. But if he did not participate because of, let's say, conflict of interest or relationship with one of the parties, and of course that continues. So in this case, there were 2 who did not vote. I think one said that he had a problem on conflict, and the other one was, I think, on leave.
Yes.
That person on leave can vote because he can, if he attends the next session, then he can vote.
So 7 justices can change their minds, and Justice Singh can't participate. She was the one who was on leave.
Yeah. On your question on, yes, as Professor Dunn said, there was an occasion where the Supreme Court unanimously reversed itself. There was a unanimous decision on the genetic plants, the
GMOs.
We call it genetically modified plants, but they reversed themselves entirely. They sent it to the Court of Appeals. I was still there. We sent it to the Court of Appeals for evidence gathering because we cannot be a trier of facts. And the Court of Appeals sent back its report, and we adopted that report. We reversed ourselves completely. It can happen, but I mean, we doesn't mean that it will happen this time. But what is the recourse if the Supreme Court says that there must be an intermediary step in the second mode? You must give a draft of the articles of impeachment to the person being impeached, and it will add so many things that are not there in the Constitution. Well, the only solution there, if that decision becomes final, is to amend the Constitution. Remember, when during martial law, the President Marcos Sr., abused his executive powers, especially the martial law powers. So when there was a new Constitution, the framers practically neutralized the martial law powers. The President can declare martial law, but within 24 hours, the Congress can revoke it. That martial law powers has to be renewed every 60 days. The Supreme Court can even reverse it, can conduct hearings. I think the only ground for the Supreme Court to conduct a factual hearing is declaration of martial law. They can receive evidence. So it will only, we'll have to wait for the next Constitution to correct this if the framers will want to correct it. Thank you.
Thank you very much, Justice. Just a follow-up question on the citation of the ABS-CBN article. I would just like to ask also why the decision chose to prioritize the ABS-CBN article over the congressional records which were available. So what was their thought process by choosing to prioritize that article over the congressional records which clearly carry more probative value? Thank you very much.
Well, you know, if you read the resolution, in the narration of facts, they said this House transmitted the articles of impeachment even without a vote by the plenary. citing ABS-CBN reports. But a few pages on, it states the resolution reproduces the statements of the petitioners, Attorney Torion and VP Sara, that the plenary voted without objection to transmit the articles of impeachment to the Senate in their own decision. And towards the later part, they even quote the resolution, the journal of the House, saying there was a vote upon motion of Congressman Dalipe without objection. The articles of impeachment were authorized to be transmitted to the Senate. So, in the same decision, there are three statements about whether there was a plenary vote or not. The first statement was there was no plenary vote. Second statement, there was a plenary vote, quoting the petitioners, VP Sara and Attorney Torion. The third, they quoted the House Journal. There was a plenary vote. So there is an internal inconsistency in the resolution of the Supreme Court. But the problem is they adopted the first one, that there was no plenary vote, therefore what was initiated were the three. When the three were dismissed, that is deemed to be the initiation. That's the big problem there. Thank you.
Thank you very much, Justice.
Good evening, Justice. Good evening, Professor. Just a follow-up question of my friend from the UAMP Institute of Law. Given the resolution and its lacking finality, does this mean if it comes into jurisprudence that the Supreme Court can just change the rules however they may see fit when it comes to impeachment proceedings?
Well, the famous answer to that is the Supreme Court is supreme not because it is infallible, but because its decisions are final. Whether it's wrong or not, it is final. So we're bound by that. And how do you correct that? If it's just a law that has been misinterpreted by the Supreme Court, Congress can pass a new law. But if it's the Constitution, then you have to convene a constitutional convention or a constituent assembly. Otherwise, you're stuck with that ruling until the next case comes along and you have a chance to reverse it.
I was about to say that the next time an official is impeached and that official raises the due process requirements of the Duterte versus House, the Supreme Court might listen to the argument that many of these requirements are obiter or are not required by the Constitution, and in a lucid moment, I couldn't help it, I'm sorry, reverse itself on many grounds that are found here in Duterte.
That's precisely the value of forums like this, fora like this, because if the Supreme Court does not change its position, at least people will remember what's said here and what's written by people like you, and when the next case comes along, they might reverse themselves. Thank you.
Sorry. So would you say that this is a sort of special case or special treatment given the facts of the resolution?
Is it a special case?
Well, it's if they don't change their position, this is carried on, and that becomes the rule. But if you think it's wrong, then voice your opinion, and if the next case comes along, raise your objection again. That's how we work to perfect the law. Thank you.
Thank you.
Good evening po, Justice. Good evening, sir. I'm Diane po from the SBCA School of Law. I just have one question po. What are your thoughts on the filing of a motion to dismiss by some members of the Senate during the impeachment trial?
Motion to dismiss by the senators.
The Senator Bato was trying to file a motion to dismiss. But it was not carried out because he agreed to amend it to just remand it.
But can it be done?
Well, my position is you cannot dismiss it because trial shall forthwith proceed. There must be a trial, and dismissing it, it's not a trial. A motion to dismiss does not result in a trial. Thank you.
Thank you, sir. Okay, thank you, sir.
Hello po. I'm Lance Martirez from UANP School of Law. And one of the questions I had was that in the Francisco ruling, like, as we all know, like, jurisprudence takes effect in law under Article 8 of the Civil Code. But my question is, what ruling do we follow? Because the Francisco ruling ruled that you need to file and you have to refer for it to be deemed initiated to the Commission on Justice. But how come in this ruling, it was already deemed that it was acted upon or filed already in this ruling? So therefore, my question is, what jurisprudence do we follow in this case?
Well, right now we are in limbo, but the moment the Supreme Court affirms its resolution, we have to follow that because that's the latest that will become final. Even if it is wrong, it becomes final. We're just bound by that.
So just a follow-up po. So if the motion of reconsideration was not approved, the only other remedy is for a constitutional change po?
Or wait for the next case and try to reverse the present decision.
Thank you.
If you have any question also for the ponente of Francisco, Justice Carpio Morales is here.
Good evening, Justice. Good evening, sir. So I'm John from San Beda College, Alabang. My question is with regards to, since you mentioned earlier that the basis for choosing for the articles of impeachment that will proceed is not on the first case filed basis. What is the basis of what will be the basis in the next coming years if ever the motion for reconsideration is not accepted by the Supreme Court? What will be their basis in choosing the cases of the impeachment cases that will be filed?
Well, it's up to the House because the House has the exclusive power to initiate impeachment cases. My guess is they will readapt and maybe make some changes to the fourth impeachment complaint because that's really the composite of the first three, plus they strengthen the first three.
My follow-up question is, since it was also mentioned that there is a possibility that in order to avoid responsibility of those who is liable for impeachment, they may file sham complaints. What will be the filtering of the Supreme Court or the House of Representatives in filtering out which ones will be sham complaints or not?
Well, this resolution now says that if it's a sham, it will be dismissed, and the one-year bar rule, of course, will not apply because it was dismissed. Remember, the one-year bar rule was imposed to prevent one who is already subjected to impeachment at the Committee on Justice level to prevent him from being subjected to another impeachment complaint. So if it's dismissed, nobody is prejudiced, nobody is harassed.
So in that case, Justice, is it safe to say that if a case is dismissed, it's already a sham? What's the standard or basis of saying that a complaint filed is a sham?
I see your point. Because in this resolution, the Supreme Court said it's ministerial on the part of the House to transmit the impeachment complaint to the Committee on Justice. And if it does not transmit, then it is deemed transmitted and the one-year bar rule applies. So everybody now will be filing very weak impeachment cases. The plenary will probably not, will just archive it or dismiss it, and then they're inoculated, immunized for 1 year. That's the problem here. Because the purpose of the ban, 1 year ban, is you will not be subjected to multiple, more than once, multiple impeachment cases. But if the impeachment complaint does not reach the Committee on Justice, you are never subjected to harassment. It's dismissed. But the court is saying now it is ministerial that the plenary refer it. So somebody will file a very weak case, refer it, that's referred to the Committee on Justice, and the Committee on Justice will probably dismiss it because it's weak. But he is already immunized for 1 year. I really cannot see the reason why, if it is dismissed by the plenary, the 1 year ban will apply. I cannot understand that.
So, is it safe to say that there is no more sham complaints since everything will be ministerial? So if you file, even regardless of the basis, regardless of the evidence, once you file, it will now proceed to the Justice Committee?
Well, under this rule, because the SEC resolution says, unless it is a sham impeachment, the plenary has a ministerial duty to refer it. So if it has some semblance of legitimacy and it's referred, but it's very weak, then the 1 year bar rule will apply. And if it is dismissed, but it's not considered sham, the 1 year bar rule will also apply under the present ruling. I cannot square that.
Thank you, Justice.
Thank you. We will have just 2 more questions.
Hello, Justice, and hello, Professor. I'm Patrick from UANP Law, and I just like a comment considering the motion for reconsideration. Would you have any thoughts on the other legal arguments that you would have wanted to include on the motion for reconsideration, or if it is sufficient as it is? Thank you.
Well, I think our lawyers, Attorney J.P. Calleja and Attorney Chris Lau, have thoroughly included all the possible arguments. So I will not, I have nothing to add. I told them I have nothing to add to what you prepared.
Thank you, Bob.
Hello, good evening, Justice. Good evening, Attorney. I'm Ara from San Beda College of Law and Human Rights Center. My question is, should the Supreme Court grant the motion for reconsideration, is the Senate bound to revive the archive impeachment, or may it still continue to disregard it altogether?
Well, my opinion there is, remember, the Constitution says once the articles of impeachment are signed by at least 1/3, the same shall constitute the articles of impeachment, and trial by the Senate shall forthwith proceed. But everything was on hold because that was questioned. Now, if the Supreme Court says, oh, it's valid, that articles of impeachment, then you go back to that provision. The same shall constitute the articles of impeachment, and trial by the Senate shall forthwith proceed. I don't think the Senate can refuse. They don't even have to vote, because that's the automatic consequence. If the Supreme Court reconsiders its decision and says the articles of impeachment are valid, then that provision of the Constitution automatically is reinstated. The same shall constitute the articles of impeachment, and trial by the Senate shall proceed forthwith. Trial by the Senate shall forthwith proceed. The Senate has no choice. Thank you.
So if I was the Supreme Court, I would include language like that. Because I will expect certain senators to say, oh, we can't do anything because it's been archived. So if the decision is reversed, then I will say that trial should proceed without any need for votes.
Thank you po.
Thank you. For our last question, this is the most asked question online. Who checks the Supreme Court?
Well, if the Supreme Court interprets a statute, a law of Congress, and Congress does not agree, then Congress will just pass a new law, amending it. But if it's the Constitution that is being interpreted by the Supreme Court, and the Filipino people do not agree, what is the recourse? Amend the Constitution. But there is something here that that we have to discuss also. The Constitution says the grounds for impeachment, culpable violation of the Constitution. So there was a case, the Joint Marine Seismic Undertaking, where China explored our territorial sea, and former President GMA allowed it under that agreement. Our territorial sea is our territory. It cannot be jointly explored, of course, by another state, because China was claiming they could explore it. Of course, the Supreme Court said that JMSU was unconstitutional. But what if the Supreme Court said the 9-dash line is valid and we have to respect it? That will be a culpable violation of the Constitution. The issue is, if there is a majority of the Supreme Court that ruled that the 9-dash line is valid, can they now be impeached for culpable violation of the Constitution? Under the present resolution of the court, they cannot be, because this Supreme Court resolution says if it's a decision of the en banc or a decision of a collegial body, they cannot be impeached for that decision. I think if in the U.S., if a federal district judge makes a wrong decision, the remedy is not to impeach him, but to appeal. Because there's still the appellate court. There are still appellate courts. But if it's the highest court that makes that wrong decision, that violates the Constitution, what is the remedy? Well, of course, you can amend the Constitution, but that takes time. Can you now subject the majority that wrote that decision to impeachment for culpable violation of the Constitution? Under this resolution of the Supreme Court, you cannot. They have immunized themselves. Thank you.
I would argue, though, that the court's statement to that effect, that they cannot be impeached, is obiter dictum, because that issue was never raised in this case. So the practical consequence, however, is the problem. So even if we had enough votes to impeach the justices, who would try them? And if they raise constitutional issues, who would decide those constitutional issues? But as a remedy, in theory, I think they can be impeached.
Yeah, because there is no other remedy, then you have to rely on the existing structure of the Constitution. If it's just Court of Appeals that made that decision, culpable violation, you cannot, your remedy is to appeal. But if there is no more appeal, because it's the highest court, can you use the impeachment mechanism in the Constitution? Under this resolution of the Supreme Court, you cannot. They have immunized themselves. Thank you.
Thank you. Thank you, Justice Carpio and Professor Gatmaitan. This concludes our open forum, and I will now give the floor to Iman.
Now, before we conclude today's program, we would like to take a moment to express our deepest gratitude to our guest speaker and panel reactor for sharing their valuable time, knowledge, and insights with us. Their expertise and perspectives have greatly enriched our discussion and provided us with meaningful learning opportunities. As a token of our appreciation, we will now present certificates of appreciation to formally recognize their contribution to today's event. May we kindly call on Ms. Gloriette Abundo to come forward and lead the presentation. May we also call on Attorney Calleja, Attorney Calleja to accompany Ms. Abundo. May we also call on our Dean.
We would like to read the Certificate of Appreciation. This Certificate of Appreciation is proudly presented to Honorable Justice Antonio T. Carpio for generously sharing his time, knowledge, and expertise as guest speaker during the Anatomy of Impeachment lecture, a legal deep dive into the accountability process held on August 29, 2025 at Tugade Theater Auditorium, San Beda College, Alabang. Signed, Dr. Ulpiano Sarmiento III, Dean School of Law, Gloriette Marie C. Abundo, and myself being the moderator of the Human Rights Center. Thank you so much. We also would like to read the Certificate of Appreciation. This Certificate of Appreciation is proudly presented to Attorney Dante Bigatmaitan for generously sharing his expertise as panel reactor during the Anatomy of Impeachment process, a legal deep dive into the accountability process held on August 29, 2025 at Tugade Theater Auditorium, San Beda College, Alabang. Signed by Dr. Ulpiano P. Sarmiento III, Gloriette Marie C. Abundo, and myself. Thank you. Lastly, this Certificate of Appreciation is proudly presented to Attorney Christopher John P. Lau for his invaluable service and contribution as host during the Anatomy of Impeachment lecture, a legal deep dive into the accountability process held on August 29, 2025 here in San Beda College, Alabang. Signed by Dean Ulan Sarmiento III, Gloriette Marie C. Abundo, and yours truly.
As this program comes to an end, we want to conclude this lecture's sentiments through someone whose leadership and dedication to human rights continues to inspire students, practitioners, and advocates alike. Let me introduce Ms. Gloriette Abundo, the President of the Human Rights Center, an institution known for its unwavering commitment to promoting justice, accountability, and the protection of fundamental freedoms. Through her guidance, the Center has championed countless initiatives and defend the rights of the marginalized and amplify voices that too often go unheard. Her passion for justice, combined with her sharp legal insight and compassionate leadership, make her a driving force in the human rights community. Please join me in welcoming the President of the Human Rights Center, Ms. Gloriette Abundo, for her closing remarks.
On behalf of San Beda College Alabang School of Law, we sincerely thank Justice Antonio Carpio for sharing his profound insights in the anatomy of impeachment, a legal deep dive into the accountability process. Our gratitude also goes to Attorney Christopher John Lau for hosting, and Professor Dan Tegatmaytan for serving as our panel reactor. We are honored as well by the presence of our esteemed guests, Justice Conchita Carpio Morales, professors, students from other schools, and our fellow Bedans. We extend our thanks to Attorney John Peter Calleja for initiating this event, Papa Dean Ulan Sarmiento, School of Law Government President Sara Reguera, together with the SBCA Volcor, Centralized Bar Operations, the Red Chronicles, and the Human Rights Center members for making this program possible. Thank you for joining us this evening, and may today's lecture inspire us to remain steadfast in our pursuit of justice and accountability. Thank you.
Okay, so thank you once again, Ms. Abundo. Now, may we request everyone to stay after this program, all students inside the venue, with the School of Law faculty and our esteemed guests before exiting the Togadi Auditorium. Now let us all give everyone and our speakers and panel of reactor a round of applause, please. May we all rise for our Bedan hymn. Again, may we request every student to stay inside the venue before we exit the Tugade Auditorium. Thank you.